Thank you, everyone. Please be seated. We are here today for the submission of 4 cases. The case of State versus Uranga is hereby submitted without oral argument. And the case of State versus Hallock is also submitted without oral argument. Our first oral argument today is State versus Brown. It looks like the parties are ready. Am I pronouncing it correct? Is it Jennisch? Okay, Ms. Jennisch, you may begin. Oh, wait a minute. Stop right there. Sit down. High school class here, Audubon. Go Wheelers. We have a high school class here, which my colleagues, they actually alerted me because they know what I do, and they complain about it, but obviously they love it. All of us, of course, not only graduated from a law school, we graduated from a college, and we all graduated from a high school. And we just want you to know that we remember being at that point in our lives. Appreciate you taking the time out of your schedules to come see what we do. And I am a Harlan Cyclone. I know you know where I live, because I certainly know where you live. And when I was a trial court judge, I was in your county a lot. So I know exactly where Albert the Bull is. We'll go now in order of seniority, and they're going to tell you where they went to high school and what their mascot is. And by the way, lawyers, you have to too. I think Mr. Sloven's done this before.
Hi, Tom Waterman. Grew up in Bettendorf, attended Bettendorf High School. The Bulldogs. Yep.
Ed Mansfield. I grew up in Lexington, Massachusetts, and went to Lexington High School. The mascot is the Minuteman. If you followed the Revolutionary War, if you watched Ken Burns' series, you might understand why.
Christopher McDonald. I went to Des Moines Lincoln High School. The nickname is the Rail Splitters, and the mascot was Abe Lincoln carrying an axe.
Hi, I'm Dana Oxley. I went to what was then Greenfield High School, where the Greenfield Tigers. It is now Nottoway Valley, and I believe they're the Wolverines.
Good afternoon. I'm Matt McDermott. I went to Kemper Catholic in Carroll. We are the Knights. And I was at your school last fall, so good to see you again.
Hi, I'm David May. I grew up in Kirksville, Missouri, and went to Kirksville High School, and we are the Tigers.
All right, now, Ms. Jennisch, you may approach, and when you need to tell us where you went to high school and what your mascot was.
I grew up in Des Moines, West Des Moines actually, but I went to high school on the East Coast. I went to Phillips Academy in Andover, Massachusetts, and as far as the mascot is, I don't remember. I just know we just said, "Go Big Blue." So that's a color.
Smurf, maybe. Go ahead.
I'm representing Mr. Brown in this matter as the appellant, and he is appealing from his conviction for attempted enticement in violation of Iowa Code Section 10.10. I've raised 2 issues on appeal, the first being a jury instruction error, and the second being a sufficiency argument, and both are very related. But I'm going to just start with the instructional error. We've alleged that the instruction, the elements are, according to the jury instruction, the marshalling instruction, is that the defendants entice the child with the intent to commit an illegal act. In this case, she is 13 years old. That's not in question. At the motion for judgment of acquittal discussion, this is when it first came up, the parties talked about the fact that a legal act within the context of this statute is not defined, and proposed, first of all, and suggested that there was no indication of any sexual intent or anything of that nature, but also broadly that there's just no guidance given to the jury as far as what the definition of an illegal act is.
Wrong. At the trial court, wasn't the argument that you need to give the jury some idea of what act you're saying is illegal, whereas on appeal, it seems to be the argument is that the definition by the judge should have, and it was error not to talk that it was an illegal sex act. Aren't you taking that a little different than what the trial court said, or what was done at the trial court level?
We're just expanding it. It's not any, we're not creating a different argument. I think under, the basic premise is that the jury doesn't know what the illegal act is. And
Today is that the word sexual should have been in there, right?
one of the arguments. And at base, if the jury is not instructed on that, that it has a sexual component, which the state has argued in its brief very persuasively that it's questionable whether really that there's no requirement that it has to have a sexual component given the change in the statute. So we'd argue that it's preserved because in the district court had the opportunity to pass on that issue, ruled against the defense. And on appeal, we've touched upon it, that the state in its brief also addresses that argument and correctly cites State v. Mesh, which addresses the issue of whether or not.
They do, they cite Mesh, but nowhere in the blue brief, the gray brief, or the further review application does the defense ever talk about Mesh, do they?
No, but, in the application for further review, in the alternative, we've asserted that the jurors need to be instructed on what illegal act the state is wanting the jury to consider.
Does it matter what that illegal act is? If it doesn't have to be sexual, can it be any of the things that the prosecutor mentioned in closing? Wouldn't all of those work?
Well, I would focus on Mesh because it talks about how even though burglary, that statute doesn't say what category of offenses would qualify as, when you're committing a burglary, you're entering with the intent to commit an offense. That Mesh says that the jurors should be instructed on it, and also the state should charge it as such to give the jury an opportunity to consider.
As I read it, as long as it's the type of act that can be committed upon another person, so not kind of personal drug use or something, but something that you can do to someone else, that it would be okay. Why is that not right?
Why is that the lack of a specific crime? I would analogize it to the other crimes. In looking at the model instructions, there are other crimes, for example, felony murder, solicitation, conspiracy, assault while committing a forcible felony. When we look at those model instructions, they actually say insert, specify the crime. And also, they've also indicated in some instances, particularly with the, assault while participating felony, the bar recommends that the jurors be given the elements of the crime that the state is alleging.
Clarify your argument here, which may be a little bit different than a different district court, but not a lot. You're not saying it has to be a sex abuse crime here. You're just saying some crime needs to be specified and then put into the instruction.
And really,
About that. So, no. It seems like we usually say an instruction is fine if it correctly states the law, right? And I think this instruction does correctly state the law, which is the statute makes it an illegal act to attempt to entice to do an illegal act upon another under the age of 16. So it's technically correct, and you're not making a constitutional argument, right? So other than that you think there could be a better instruction, is this instruction actually wrong?
it's wrong insofar as, here's the problem with that, because when the jury is given illegal act, that doesn't, in and of itself, the jury doesn't know what statute, what statutory violation, what crime. I mean, what lay people think is bad or is a crime may not necessarily meet the statutory definition of, under Iowa code. So that's a problem right there. Granted, I think that
Is a problem, but it's a problem that's codified. I mean, the crime is committing and attempting to entice and then committing an illegal act, which is what the jury instruction said. And if you're not making a constitutional argument that there must be some specificity for this to be permissible, I guess I'm not seeing the error necessarily.
But if you would look at, the other crimes that I've talked about and, in the jury instructions there with the robbery, felony murder, with the involuntary manslaughter, the public offense, again, those statutes do not specify exactly.
Do it differently. And they seem to be okay with that. There's not a constitutional issue. So just because our state does it differently with respect to burglary, I'm not sure that we necessarily have to have more specificity here.
Would apply to, if mesh applies to other crimes, then it should apply in this crime as well, because the similarities are that the statute doesn't name the crime. And again, go ahead.
Told by what district court, what was argued at district court and what is in your brief. Your brief says, nevertheless, Brown argues that the jury should have been further instructed that an illegal act means, quote, an unlawful sexual act upon or with the alleged victim. And then you repeat that and says the jury should have thus been instructed that an illegal act means an unlawful sexual act upon or with the alleged victim. Seems to me in the briefing, you're saying you have to have that word sexual in there. And yet at the district court, I do agree with probably a broader argument was made. But correct me if I'm wrong, isn't the brief focused on we should have, or the jury should have been told a sexual act means illegal?
Really, but the issue is, and the parties talk about this too, is that the defense wants the state to narrow their focus. And again,
Asking us to do in your brief, you've said several times it should have said illegal sexual act. Just am I wrong on that? Isn't that what you're asking for?
that is correct. But again, what's the essence of it? The essence is the jury was not instructed on a crime, least of all a crime that had a sexual component.
To me to be making a reasonable point. That is, the argument below that was made below by trial counsel was, you need illegal act leaves the jury at sea. They don't know the law, so you need to tell the jury what's the illegal act that the defendant was attempting to, was specifically intending to commit. And that's one argument. The argument you're making here seems to, at least in your brief, as opposed to maybe in your argument today, seems to be that it has to be a sex act, that it has to be an intent to commit a sex act. And that argument I struggle with a little bit, particularly because 710.104 provides that the defendant doesn't have to register as a sex offender unless the illegal act was sexually motivated, which makes it sound like clearly the illegal act doesn't have to be a sex act. So, I mean, what precisely is the argument you're making here to us today?
Well, the argument is that, initially as it was raised that the jury wasn't told what the act is. Secondly, and we went further on appeal, that there was no, it should have some sexual component to it. Again,
Two, when you say it has to have a sexual component, does that just kind of obliterate the statute 710.10 sub 2? I mean, that's the one that comes right out and says commit an illegal sex act.
exactly. Like I said, I do acknowledge that the state has, that has brought up the legislative argument that was also explained to the court. Explained to the court explained to the parties about that. But regardless, in arguing it before the Court of Appeals, they didn't address, they just addressed that this is a correct statement of the law. So, and for further review, part of it, maybe, wasn't phrased, in the briefing, initial briefing, but the essence of it is that they weren't told what act. And that's really the crux of the problem that, we see on appeal here is that there's no guidance.
It's instructed as a specific intent crime, and our cases seem to treat it like that. Would it matter if this specific subsection were more of a general intent crime? Meaning the statute means something like this: the defendant attempted to entice the minor for no legitimate purpose, or with no legitimate purpose. If that's really kind of what the statute meant, would that be okay?
The statute, that would not, like I said, I think implicit in the statute is that, the state has the burden to prove or present, offer theories of prosecution as far as what is it they're defending against, as far as what crime. And in this case, the state did not offer anything concrete, just in fact, in closing arguments, the prosecutor basically just said, it's up to the, probably in the jury discussion or jury selection or jury instruction discussions, they said it's up to the jury to decide that, what is the illegal act. And the problem here is that what the jury thinks is illegal may not statutorily match up. And as I've said, when the bar, the committee offered these model instructions, I think that they did contemplate, perhaps this is, that's what the state would do, would offer specific alternatives. They would be plugged into the jury instructions, just as in the other offenses that I've named.
Instructions. They did, I think it was number 100.12 is the one they used. And in the comment of that uniform and jury instruction, they do cite mesh, and it's relied heavily upon by the state. But I said earlier, it's not argued anywhere in any of your briefing, is it, other than what you're saying today?
But at the same time, again, I think that I would just focus on that's what the issue is here. That's what the problem is.
See the evidence, because we're getting down on time here. So you have a chance to say something before the state responds. When you said there was no evidence presented, I thought that was curious that when he was questioned by the police, he made a comment that, well, I thought she was 18. Isn't that an indicator that the jury could rely upon? Pretty strong. I mean, if he was just going to give her a ride or give her a lollipop, everybody knows you don't have to be 18 for that. Doesn't that indicate something that the jury could hang their hat on for an illegal act? Why would it matter if she's 18 or not?
Well, again, that asks the jury to actually, as the prosecution stated in its closing argument, it's just basically there's nothing good can come of this. And again, on appeal, as with the attorneys, the judges, there is nothing. There's nothing to link that what's bad to what's an illegal, and they do. It would not. It wouldn't be a fair trial here if what the jury decided on was the bad act is the equivalent of an illegal act. And you pointed out the body cam video. The officer towards the end, maybe 3-minute mark, makes the comment that it's not illegal, but it's not right. And again, in reviewing, that video, a large portion of the discussion is the officer trying to get Mr. Brown to admit to wrongdoing and to just have a discussion, shaming him that you shouldn't be talking to young girls. You're a 70-year-old man talking to a young girl in public. You shouldn't be doing that. Again, that is the tone of the interaction.
Than that, wasn't there also, according to her testimony, which the jury could have found believable, he was stalking her around the store. He was following her. She was trying to ditch him 3 times. She tried to go to the payout on the self-payout and couldn't get through it without him bugging her. There was way more than just him talking. Her tummy siren obviously was going off. So wasn't there more evidence than just talking? And I forgot to mention the car pulling up afterwards and saying, "Hey, you want a ride?"
All that shows is, okay, so what specific illegal act, what bad thing was Mr. Brown alleged to have committed? And that it is up to the state has a burden, again, to narrow down what their theory of prosecution is for that type of case. And again, we don't, again, we point out those facts, but at the same time, there was nothing else. We don't have anything that we see in the other enticement cases, for example, bribery, any kind of assertion of authority or control, or, he's an older guy, asserting, like, get in the car. It was a simple offer, which she said no, and then he drove away. That's also something to consider within this mix of, circumstantial evidence about his intent, which we know is very difficult to prove with, there's really a lot of cases not allowed direct evidence to say that.
Come back on round 2. Mr. Sloven?
Thank you, Madam Chief Justice, Counsel. Good morning. Louis Sloven. I attended Valley High School in West Des Moines, go Tigers, also by way of Central Academy in Des Moines, and I'm just going to guess the Sig Figs. Probably not an official mascot, but anyway, may it please the court. Madam Chief Justice, I think you're correctly identifying that the challenge that's raised in the briefing on appeal is not the challenge to the instructions that was argued below, which was failure to specify particular illegal acts. And you can tell that just by reading the briefing. Another easy way to tell that is because the ask in the brief on appeal was, you should have had the instructions just say, intent to perform an illegal sexual act upon her, and didn't even ask.
I'm going to jump past that because I think that one, to me, is a much simpler one. How come, Mr. Sloven, when the defendant said, "Can you give us an idea in the instructions of what are you talking about?" What's the big deal? You really want a jury to leave it up to their own devices to figure out what is legal and what is illegal, whether, even if it's, take the sexual component out. You're defining the word attempt. That seems like a really simple word. And when somebody asks for the word illegal crime act to be defined, no. Help me understand how that wasn't perhaps maybe incorrect by the court.
Well, part of this is that to the extent that there's a problem, it's baked into the statute deliberately. The statute specifies intent to commit an illegal act. The legislature is presumably aware of mesh and the dichotomy it draws. Choose this language to do this.
From, sort of the omniscient legislature that reads all of our cases. I don't even read all of our cases. And I mean, Mesh was saying that you had it in the burglary context, you have to specify the felony, and then it was just distinguishing some cases in other states that said no based on a wording difference. But I think it's a bit of a reach to draw from that when there's a different statute that says intent to commit an illegal act, you shouldn't define the illegal act for the jury. The jury doesn't know what's illegal and what's legal. If they do, then I wasted 3 years in law school. I didn't need it. I mean,
part of it is that Mesh would have been a much shorter opinion if there weren't a need to consider the differences between these two different kinds of language. And the language that's used in 710.10.4 here describes a general criminal intent, not a specific intent to commit a criminal offense within a certain category. And that's the difference. Now, the universe of acts that are illegal and can be committed upon another person is vast, and the state isn't required to narrow down.
Here they had some ideas in mind. They could have wouldn't it have been more fair to the defendant, instead of just allowing the jury to say, oh, he's up to no good, therefore he's guilty, to specify the illegal act? We've got the stand your ground cases, which, like Ellison, which we decided much more recently than Mesh. And in Ellison, we said in order that the illegal activity, which is part of the stand your ground justification defense, that illegal activity should be defined for the jury. You shouldn't just allow the jury to speculate on what's legal and what's illegal. So why doesn't that rationale apply here?
Part of it is that the jury instructions correctly stated the law. We could optimize them further, and maybe some more advisory guidance would be good, but there's no way to say that these instructions didn't correctly state the law.
But that doesn't mean that a jury instruction should just quote the statute. I mean, yeah, that correctly states the law, but a jury instruction that asks the jury to decide what's legal and what's illegal, that seems to me that's not a jury instruction that's appropriate, is it?
The other thing to consider is that you're saying, and I agree with you, that lay jurors don't act with perfect knowledge of what is legal and illegal. Neither do defendants, neither did Mr. Brown. What we're describing is a general criminal intent, kind of equivalent to the way that we think about malice aforethought, an intent to do something unlawful. And the knowledge of its lawfulness is not...
It says, with the intent to commit an illegal act. That doesn't sound like a general criminal intent. That sounds like a specific intent to commit a specific illegal act. Why not tell the jury what's the illegal act?
That the state is allowed to allege all of them in the alternative, and without being held to a particular...
If they think that there's two or three that the defendant that there's sufficient evidence that there's two or three possibilities, they can include all of them in the instruction, but at least include some guidance, right?
I agree that would give the jury more guidance. It would, I mean, the jury instructions are already correct. At best, what you're describing is that the court could give instructions that say an illegal act includes but is not limited to, and then describing particular acts that the state and the court... Yeah, well, easy until you start getting a long list of potentially...
Using this to his advantage, he or she, I can't remember if it's a man or woman, he or she argued throughout, could be kidnapping, could be this, could be that. So I give you the defense at their closing could have addressed A, B, and C. Maybe the prosecutor said it could have been A, it could have been B, it could have been C. Defense could have said, yeah, oh, let me tell you about A, B, and C. Okay, it's been addressed. However, rebuttal, I saw on the record, he threw in D. He threw in robbery. He threw in a crime that defense has no opportunity, even by words, let alone instructions. So it just seems to me that that's kind of loosey-goosey for the state to be able to just throw some out and have nothing for the jury to rely on as far as guidance.
So I think that the way to ameliorate this, first of all, an objection to a new theory of liability that was not argued before it might have been available. But if the defense, and the one objection that I saw from the defense about a thing that may not have been illegal, that the jury may have believed was illegal, was giving a stranger a ride somewhere. If that's the case, the defense can ask for an instruction that specifies it is not an illegal act to, and then particular acts. Now, the jury, and Justice McDermott, I believe you pointed out that unlike burglary, which is a felony, and jurors do not have the knowledge to know what is and is not a felony, this is a more open universe of illegal acts with a common sense. The only factor that could limit it is a common sense understanding of what acts can be committed upon someone. And the acts that the state was arguing are all acts that illegal acts that it would have been entitled to a definition of if the court had decided to give definitions for acts that were supported by the evidence. Assault, kidnapping, false imprisonment, sexual abuse, primarily sexual abuse, because the evidence in this case most strongly militated towards intent to commit some sort of a sex act with the victim.
Additional instruction that said an illegal act includes the following. Wouldn't there also have to be an instruction where the jury found the elements of those offenses as well?
The jury would have to find intent to commit an act that satisfied those elements. But here we're dealing with an act.
by the elements of the other acts, and the jury would have to at least find those as well, right?
No, but we're in the attempt realm, so they wouldn't have to find those elements were met. They would only have to find an intent to commit them, right?
To be identified to further define the illegal act that's identified in the illegal act instruction.
Now, you say, Chief Justice, isn't this easy? Well, it's easy when you have one or two illegal acts. The problem is that the statute allows the state to allege all possibly illegal acts in the alternative.
Limited to, that's what that means. I mean,
50 pages long, and we scratched the surface.
We've just been down the road in the last few years in stand your ground, and I'm not hearing the state saying this is impossible. I mean, we've said the same thing in our stand your ground cases. Don't tell the jury the defendant can't rely on the stand your ground defense if they were engaged in illegal activity. Tell them what the alleged illegal activity is.
That makes more sense in the context of illegal activity that satisfies the Lorenzo-Balthazar test of a nexus to the act of purported self-defense, where there's that limiting factor that then requires the state to identify illegal activity that satisfies that legal test. Here, it's just a general criminal intent to commit an illegal act, and the whole, right. Now, I want to touch on harmless error too, because Justice McDermott, I think you're right that all of the theories that were mentioned by the state would have been supported by sufficient evidence, and we're clear from the evidence here. The state can allege all of them in the alternative, so that if a juror says, well, I know that it had to be either intent to kidnap, intent to assault, or intent to commit a sex act, I just can't choose which, state's entitled to a conviction from that juror on those findings. Now, the jury here, or
the difficulty of applying harmless error on a sufficiency challenge when the elements weren't included in the instruction. And it seems, I mean, I know the U.S. Supreme Court's been kind of divided on this issue, but that seems problematic, right? To say that even though the jury didn't make a finding here and they weren't asked to make a finding here, we can affirm the conviction because we think there was sufficient evidence, which is, you know, kind of like a directed verdict motion in criminal cases. Yeah.
distinction. I'm not saying harmless error on sufficiency of the evidence. If the evidence is not sufficient, don't find harmless error. What I'm saying, but, and I want to build on.
Jury instruction based on overwhelming evidence of guilt, that still seems a problem to me if there's not an element in the jury instruction.
I think it's a different issue when you're talking about omission of an element entirely, where the jury made no finding, versus definition of an element that we want to encourage courts in the future to give more. But you can't look at this and say that the jury didn't make a finding beyond a reasonable doubt that he intended to commit an illegal act upon her. They made that finding. They were urged to. The instructions required that finding. And in fact, that was the focus of all of the argument that was being made. The defense did not argue that here are some ways that the, various, by a technicality, some acts that the prosecution is talking about might not have been illegal. The defense theory was they haven't disproven a good Samaritan intent. The battle was very clearly joined, and the jury, in rendering this verdict, found beyond a reasonable doubt that that was not his intent. His intent was to do something illegal to her. They made the core finding as required by that element.
Argument. Am I correct that questions were asked? Must have been during the interview with the cops because the defendant did not testify, correct? Okay, so it must have been during the interview. Aren't I correct that they said, was she in trouble? Did she ask for help, or did they ask that of the victim? There were questions like, did you ask for help, or did she ask for help? Was she lost? Was she hurt? And all the answers were no. Do you remember?
The defendant did not ask those questions to her. She was asked those questions on cross-examination by the defense attorney. Did you talk to a security guard? Did you call 911? Now, she called her parents in the moment, put them on FaceTime. Calling her mom is kind of like calling 911 because her mom is a 911 dispatcher. It just meant that the call wasn't recorded, annoyingly. But you understand why she did that. Look at the statements that he makes when he is under the impression that the officer has viewed the video from the Jewel Osco. That's, I think, the main reason why he doesn't attempt to claim that he thought that she was in trouble and that's why they interacted. Because he is aware that the video footage, should it exist, would make that untenable, and that he has to say, make the jury found untenable claim that he thought that she was 18. Otherwise, there's no plausible explanation for his conduct. He knows that her experience of it and what's shown on the video shows an intent to strike up a conversation that is, the kind of conversation that you would expect if you were trying to pick someone up.
If she's not 18, yeah, it would not be appropriate for me to have asked her if she wanted to ride.
Yeah, I don't know that that was limited to the ask for a ride. I think that that was discussing his entire course of conduct, that it wouldn't be appropriate if she was under 18. Now, the jury got to see for themselves. She was, at the time, just turned 13. At the time of trial, she was 10 months older than that. The jury got to see for themselves, and if the jury finds that it would have been clear to him that she wasn't 18, they can infer that he was lying about what happened and lying about that there was no plausible non-criminal intent that he could claim. And he knew that in his conversation with the officer, which is why the best he could do is to say, I thought she was 18.
Times during argument, you've mentioned that this element of an illegal act was more like a general intent crime, like having malice aforethought. But at least as is instructed here and historically treated, it's been treated as a specific intent crime, and you're not deviating from that.
What I'm saying is attempted enticement, as defined here, is a specific intent crime, enticing with the intent to commit an act that is later done with general criminal intent. So specific intent to commit an act, and that act later does not require any specific intent itself. It is a general criminal act.
Not have to agree on what the illegal act is, correct?
The statute is written that way, and that's consistent with Iowa case law and alternative means of committing the same crime.
There's a category where this person is a good Samaritan. There's a category where he's intending to commit a crime. And then there might be a gray area where he's intending to behave in a way that is weird, inappropriate, but might not be criminal. Isn't there a middle category that a juror could land on?
Yeah, I'm out of time if I can respond to the question. Thank you. Really not in this case. And the reason why is because any sex act with this 13-year-old would be a criminal act. If there is an intent to engage in any sort of a sex act or, entice further, advance it towards engaging in a sex act, right? As long as there is the intent to develop and enable that later sex act, that is an intent to commit a general criminal act. And the defense seems to acknowledge and recognize this in, arguing that this is a good Samaritan intent, not arguing that this is creepy but not illegal.
But you would agree that might be it. People sometimes act in a creepy but not illegal way, but that's kind of a hard argument to sell to a jury as opposed to saying it's totally innocent. I mean, there are at least, maybe not in this case, but there are 3 different possibilities sometimes for conduct that seems socially highly inappropriate, right?
So I think that's generally true. The problem is that once you take out, the thing that differentiates your middle category is the lack of intent to consummate, the lack of intent to accomplish an act upon, right? The sort of like voyeuristic look but don't touch, sort of what the guy in Quinn says his intent was, that he just wanted to make eye contact and then use that later for fantasizing. But once it becomes clear that there's an intent to commit an act upon, now that middle category is gone. And that's the finding that the jury was asked to make.
Evidence that shows in the state's view the evidence was sufficient to sustain the conviction.
Actus reus of attempt to entice is accomplished at the moment where he waits in the parking lot or nearby, pulls up and asks, do you need a ride, inviting her into the car. That's the attempted, that could almost count as completed enticement, but you don't need to decide that because this was charged as attempt. It's at least attempted enticement. The specific intent is established by inference from all of the other facts in the case. From the initial encounter where he stares at her, then follows her 2 aisles over, looks her up and down, starts asking her questions, follows her through the store, waits at the self-checkout for her, and she's like delaying to try to, wait for him to complete his business and get out. That's not gonna happen because his business is following her. And then she gets out on the street, he comes up and he's waiting for her. That's why I put Lefebvre in that notice of additional authorities, because waiting can be part of the actus reus of attempt. It's also indicative of that specific intent to accomplish something. And then the admissions that he makes to the officer later, specifically the lack of any claim of pro-social intent. He never once says anything to suggest that he thought that she needed help. Instead, it's about what he wanted from her, and his view of her as pretty. Some older petite ladies look young, and acknowledging that his interest in her would have been inappropriate if she were 18, but of course she was very obviously not. So all of that together, we're very comfortable inferring specific intent from a collection of facts and circumstances. Thank you. Oh, please.
If I were the trial court judge and you were the prosecutor and I was persuaded by her argument, and I'd say, what do you want the instruction to say? We're going to talk more about it. What could it say that wouldn't be so far 100 pages, 200 pages? What could it say at a bare minimum to give a jury an idea of what is an illegal act?
It would have to use included but not limited to. It would have to define the various illegal acts that we think are real possibilities and potentially supported by the evidence, define them each in the alternative, clarify that you don't need to find those elements are actually satisfied. All you need to find is an intent to commit an act that would satisfy those elements if the facts are as the defendant intended or believed them to be. And then it would have to, again, specify that the jury doesn't need to agree on which one, but has to find, and may find that they are convinced beyond a reasonable doubt that he intended to commit an illegal act that is not listed. And that's kind of one of my big problems with the idea that the jury needs some guidance as to what's an illegal act, is because as the law is written, they're free to decide that he intended to commit an illegal act upon her. That is not specified, that is not urged. They're free to make that conclusion.
Burglary, this is not such a burden on the state. The state gets burglary convictions. Why do you think that this is so hard?
Part of it is that it's not just that it's hard, it's also that it's unnecessary. It's that the universe is wider, necessitating more alternative instructions. It's that the burglary has been written in a way, and the legislature wrote this in a way, indicating a choice to take 2 divergent paths. And it's also that once the person's inside the house, that is, right, that helps narrow down their intent in a way that makes a proliferating universe of alternatives less of a factor to worry about. Whereas here, we're drawing inferences of a much wider possible universe of potential. Now, in practice, this ends up being a lot narrower because of his admissions and because of common sense about why a 70-year-old is going to be interested in a 13-year-old girl. But the potential here is for these multiplying alternative instructions that stretch on pages in a way that we don't have with burglary.
I know you just thought of this potential jury instruction on the fly, but you said included but not limited to. That seems to me that it doesn't solve the problem. Okay, so I mean, to be correct and to solve the problem that the defendants raised, it just needs to be illegal act means, and then the state's going to have to pick a horse or several horses. But if you leave it open-ended, isn't that exactly where we are now? The whole universe of criminal activity?
Is inherent in any jury instruction that correctly states the law. And that's just how the law is written, that any illegal action can satisfy. And the jury gets to make findings about.
Well, but the district court has to find that there's eventually support for it, whatever it is. And presumably the state can say there's support for A, B, C, D. The things they have thought of, isn't that enough?
The problem is that if a juror says, I don't believe A, B, C, D that the state has alleged, I think it's an additional thing, E through Z, that is illegal but is not specified by the state. That person should convict, and the instructions should be written in a way that leads that juror to convict. And if they're not, they misstate the law.
And again, in burglary, I mean, I'm sorry that we taking, but these dialogues with both lawyers are helpful to us in deciding the case, or at least to me. But why? In a burglary case, if the state's theory is that the defendant broke into the house in order to commit a theft, then that's what will be, or commit a robbery or whatever, then that's what'll be the state will specify. A juror doesn't get to then make a conviction because they think, based on their own personal view of the evidence, that the defendant may have intended to commit a sexual assault that's not specified in the instructions. And that we don't view that as a problem. So why is it a problem here?
You that it's interesting and worth talking about. That's why I addressed it in my brief, even though it wasn't raised by the brief, and so I don't think is a ground on which we can grant relief here. But to answer your question, what you're describing, like, you're zeroing in on the very narrow universe of potential felony offenses that that can be committed, that you can commit a burglary with an intent to commit. Whereas, and that's part of what makes it more amenable. The other thing is that we're uncomfortable with jurors applying lay knowledge to determine whether an event, something they think is illegal, qualifies as a felony. And that concern isn't present here. And that's what you see in all the cases that Mesh describes that cite all of these other burglary statutes, that because the legislature specified any crime, we leave it open and we don't require an instruction or a specific allegation of a particular crime that the defendant intended to commit. It's satisfied as long as there is a general criminal intent, and you don't need to define the elements of any of the multifarious crimes that fit that much broader category.
State's argument, he was up to no good, good enough.
The argument is you have we still define out the elements of what attempted enticement is. It has to be an actus reus attempt, overt act evincing a purpose to entice, with specific intent to commit some sort of unlawful, illegal act upon her. And yes, that is a subset of he's up to no good, but is it the specific area of up to no good that violates the statute? And the statute is written in such a way that it is intended to be triggered upon that finding. Thank you.
Ms. Jennisch.
Thank you. I wanted to take the opportunity to address the sufficiency argument, which is related to the idea of that the state hadn't proved he had the intent to commit an illegal act. And as Justice Christensen pointed out, that's essentially what the prosecution's theory was. He was up to no good. Actually, in closing, the prosecutor hammered that. And the theme of this case is pretty much stranger danger because, starting with jury selection, the prosecution goes through all the prospective jurors, many, I should say. Again, what is your idea of stranger danger? Do you have children? What does that mean? Again, this theme was brought up, in closing argument. And again, in this case, what do we have? We just have a 70-year-old man. He is making a 13-year-old feeling uncomfortable. Evidence, he's following her in the store, but, according to the testimony, essentially the conversation was pleasantries. Hi, what's your name? He's trying to, one could view that he's just being friendly.
That girl, she did all the right stuff. And she put her mom, and I think, by the way, any mom is 911, not just if you're a dispatcher. But anyway, but my point is, do we have to wait for something to actually cross the line and become a crime? And this is an attempt, isn't it, to entice. So the up to no good, and the creepy, all of that, isn't a lot of the evidence that supports all of that. We don't have to have evidence that actually shows those things happened, just that it's going in that direction, correct?
There's no evidence, any additional evidence. Again, we're relying on inferences based on, circumstantial evidence. And again, that's part of, part of the issue here is that the jury doesn't have anything beyond, him offering the ride. She declines. He drives away. She's feeling uncomfortable, and scared. That's not an issue whether or not, she was justified in feeling that way. Again, she did the right thing. called her mother. But in a case like this, when we're talking about what's a rational inference from, these limited facts, and, our
Practical concern that I think the state is raising in a burglary case or even in the self-defense context, there's really a narrow universe of things that you could logically infer that somebody is doing under those circumstances. Whereas here, he's approaching this young girl. He admits it'd be inappropriate if she were under the age of 18. But there's a whole universe of things, of illegal acts that he could have committed upon her. How is that instructed in a practical way that doesn't just make the jury instruction overwhelming?
Oh, I'm sorry, are you asking for a proposed instruction?
What does that instruction look like? Does the state have to pick a theory, 2 or 3 theories? Mr. Sloven said illegal act means these things, limited, including but not limited to, but that doesn't seem to solve your issue, which still leaves the whole universe of criminal activity available to support the conviction. So how does this get instructed?
I think that, we just have to look at the other offenses that I mentioned, that talk about, when it involves an intent to commit another crime. And in those instances, the parties, the court, when they're talking about instructions, the model instructions say, name the crime, name the act. And as I said,
But what acts would you have wanted the state or the court to instruct on?
Well, at base, I think it's just that the state should offer one alternative, multiple alternatives. They do that in other cases.
One that's asking for this instruction, the state has offered what the model instruction is, and you're asking for a different instruction. It seems like you should be the one to at least provide something. So what would that instruction have looked like? I think originally maybe there was an...
Name the offense, and also, but also in addition to that, have a separate instruction defining the elements of that offense. That would make things a lot clearer, and that's what in other cases is done. As I said, in conspiracy and.
So the jury should have been instructed that it could have been with the intent to kidnap. Here are the elements of kidnap. It might have been a sexual assault. Here are the elements of that. It might have been just a regular assault. Here's that. It might have been to harass. Here's that. It might have, false arrest. Here's that. Is that what you're envisioning that these instructions should have looked like?
Ideally, that's a place to start, at least, the naming of it.
Of that, and I think I am persuaded now, or at least concerned, by giving a few examples, you're going to make a juror, and I've been around a lot of juries, you're going to make a juror think, well, I do not see A, B, C, or D. And I just wrote down some real quick things that, in my experience as a juvenile judge, I could think of why an adult would want a little kid like that. Child porn. Can you help me go rob a bank together? You'd be a great decoy. Contributing to the delinquency of minor. Maybe he wants to just pull her out and not have her go to school, whatever it may be. There is a lot of stuff out there that somebody could use a kid for to pull off. And I'm nervous about naming a few. I think we've all talked about the majority of what we think it probably was. But does that close the door for anything else? And the legislature said an illegal act. They didn't say these acts, any illegal act. So isn't that a problem by saying some, that you're going to give the jury the message that they can ignore everything else?
I think that I would just go back to the problem with the instruction in this particular case. I know we can also look broadly in terms of stranger danger here, but I think it's also I wanted to point out too, we're all thinking maybe something sexual. Is that
So,
but the court at sentencing found that it was not sexually motivated.
so
the universe of offenses.
District Court here finds that under the second part of 710.10 sub 4, that the illegal act was not sexually motivated such that this defendant has to register. Does that mean that the district court should have instructed, among the list of things that the prosecutor said here, one of them was sex abuse? Should the court have instructed that there wasn't evidentiary support for that issue? And therefore, if that's the illegal activity that the jury had in mind, that they should acquit?
So the question is, should the judge sua sponte?
So,
By either, I mean, it wasn't even part of the discussion. So, I mean, I think that,
think through how this instruction would look, because I think there has to be evidentiary support in the record to support whatever illegal activity the jury might convict on, right? And so does the court have to go through and say, I don't find evidentiary support for these particular crimes, but maybe for these crimes, for assault, for harassment, for some of the other ones, for kidnapping?
so I think that, again, you know, in flipping through the model instructions, that's what the parties are, you know, told. You know, if alternative A, B is not met, then it's not instructed. I think, you know, in other situations, you know, the court has the discretion, or, you know, if the parties argued, obviously, but if the evidence does not support the submission of those, of that alternative, then they shouldn't be submitted to the jury. And I would also add to, oh, yes, Ms. May, you have a question? Go ahead. No, I mean, I just wanted to also add, you know, in, you know, this court before has talked about, you know, the inflammatory stranger danger, and this was drilled in, starting from jury selection, and the prosecution basically said there could be no, you know, no good reason for him, 7-year-old, to offer her a ride. But you know, what struck me is that how short a time the jury took to deliberate. I mean, they were given the case at 4:24 in the afternoon. They come back with a verdict, you know, finding him guilty. And as we talked about, you know, this nebulous idea, what is an illegal act? I mean, the fear is that really it's not the jury's job to, you know, to find whatever nebulous illegal act qualifies. And really, I mean, there was discussion about, you know, there's third category of behaviors.
I will interrupt you now. So anyway, I just have one sort of narrow record question, since I see you're about out of time. In your brief, in the error preservation discussion, there's reference to the district court rejecting proposed language, and I wonder if that might be a typo or if I'm just missing something. I did see some suggested or some proposed instructions, but I don't think those proposed instructions get brought into the actual objection to the jury instruction.
The proposed instructions that, I mean, as memory serves, that are filed in the court? Yes.
Those instructions, and sometimes I can't, it's harder to see who filed what.
Parties and whether or not those are the actual ones that were.
I don't see is just sort of comparing with the brief. The brief is talking about the district court rejecting particular language, and I just don't think that at the jury instruction objection hearing that there was actually like the defendant saying, you need to give X, Y, and Z. It said that the defendant was saying, why aren't you giving A through Z or whatever, right? Or whatever you want to give. Is that am I making sense? What? Okay.
Again, you know, I humbly admit that, you know, it wasn't, you know, artfully stated or argued or whatever, but I think that we've just identified what the problem is here. And so at the district court level,
Questions for you on this point. I promise I'll be done. Does it matter if the defendant intends to do something that he thinks is an illegal act, but it's actually not?
does it matter? I don't, again, we're, you know, it's racking my brain with this hypothetical, but, you know, is it,
It seems like
well, I guess the statute leaves it unclear. And
for example, let's say he wanted to kiss her neck. That would be illegal because she's a minor. And then if you look at like the indecent contact with a child statute, that actually doesn't meet the elements of the offense. Is that enough to sustain a conviction or not?
evidence of what he thought was illegal or not? I think that I guess what he thought would be illegal, with that, I think that also, I think that there could be argument that it would be relevant because, again, that would be objectively, you know, speaking to what would a reasonable person in that position, you know, what would they find to be an illegal act? You know, again, I really don't have, I don't have a very good.
Assaulted at that moment.
That's why it's, you know, we're not saying that, you know, he may have, you know, there may be, some people may interpret it as assaultive. But again, the question is, in the context of this crime, you know, what is it aimed towards? You know, we've had other cases, you know, similar icky, you know, behavior, what we, you know, this court has called, you know, perhaps not appropriate but at the same time, for the purposes of the statute issue, it's not illegal. And that is not to say that has nothing, you know, bearing on what, you know, may be considered in society.
Being creepy a crime, huh? All right, I think we're done. Thank you. All right, the case of State versus Brown is hereby submitted, and we'll take a brief pause as the attorneys prepare for our next oral argument, State versus Porter. And Audubon, you're welcome to stay, or if you need to leave, you can leave at this point between cases. We now have State versus Porter, and Mr. Newkirk, you may begin.
May it please the court, counsel. I represent Andrew Porter. We're appealing from a motion to suppress in which the court found that Mr. Porter did not have standing to challenge the search of a blue backpack. We contend that Mr. Porter had standing to challenge his search, that he did not abandon that standing, and that the search was thus unconstitutional. We find that Mr. Porter had standing for 3 reasons. He has a privacy interest in his property within the home of another, that Mr. Porter did not actually abandon his property inside of the home, and that if it was abandonment of his property, that any abandonment of Mr. Porter was not voluntary. We have established in State v. Brown that a person going into someone else's home has an expectation of privacy within their property that they bring in. They do not expect that someone else can get into it, search it, or do anything. In this case, Mr. Porter had nothing to do with the home that he was in, wasn't on the search warrant, and went inside of the home and had his backpack in the corner of the room with him. When
Throughout the facts of this case, he never once said, hey, that's my bag, that's mine, or held it close to his body. This is not that case, right? So even going into a home that wasn't his, I just want to make sure that's very different than some of the other cases. But in this case, he did not outwardly say, that's mine.
at no point did Mr. Porter outwardly go, that is my bag, and sit there and try to say that is his. However, this is not a case where police came into a home and didn't know whose bag it was. The police continuously told Mr. Porter that this was his bag. When Mr. Porter was brought outside to a van and was being questioned, they asked him, what did you bring in? He says, a Greg bag. They then ask him, well, what about the blue backpack that you brought in? At that point, he says, I don't know anything about it. He doesn't say it's not mine, but he doesn't say it's his. He just says, I don't know. Once they bring Mr. Porter back inside, they also ask him, whose backpack is this? At that point, he says no. However, the officers standing around Mr. Porter point out to everyone else, well, isn't that the bag you carried in? And then someone else, yes, that's the black bag you carried in. They're very aware, and at suppression hearing, within the transcript, you can find that the officer notes, yes, we knew that was Mr. Porter's backpack.
Facts, you said that he acknowledged readily the gray bag. Would I be correct to assume there was nothing illegal in the gray bag?
Your Honor, I cannot say, but I do not believe there was anything found illegal in the gray bag. It was found within the blue bag once they were searching.
About cops and experience and stuff. The gray bag, he said, that's mine. It has nothing illegal in it. Blue bag, which has some illegal things in it, he says, I don't know anything about it. And you're saying that's not denying ownership?
It is not denying ownership to the point that is abandonment. That is why, for a couple of reasons, we say, A, it's not abandonment in the sense that, first, once the officers tell Mr. Porter that is his bag, they then ask him, is your inhaler in the bag? Which he answers, no. They then ask him, well, are there any drugs in the bag? He says, no, none of that. He's answering questions as if it's his bag. He's not denying.
Yes, though this, I'm thinking about Bumpus. And everybody knew that what Bumpus was throwing away was Bumpus's property, right? And yet by throwing it away, he's able to abandon it, correct? And so I don't know why we should say that a verbal throwing away, which is what it sounds like your client did, why shouldn't that count?
To be clear, like you said, Bumpus, he threw it away. And the court in Bumpus said that we look at, if you deny it, like your words, your actions, or other objective facts. Actually, specifically it says, and other objective facts. We're looking at the totality of what we have here. And in Bumpus, it's a physical act. It is more than just saying, I don't like something. If I was to go into work and say, I don't like my job, that's one thing. But if I was to leave work.
Say that, right? That you hate your job. So you do agree, though, that he could verbally consent to letting them search that bag if it was his, right? So if he could verbally consent, saying, go ahead, search it, couldn't he also say, not mine, I don't care what you do with it? Aren't those things sort of similar?
And I know it's within some federal circuit cases. It is noted, I believe it's U.S. v. Hawkins, that we don't just establish a person's rights to property by saying it's theirs. Therefore, we should not disestablish just by a statement of disclaimership of any sort of ownership.
And do what's allegedly a drug house carrying something? Couldn't that person be a mule of some type? I mean, we're talking about people who know a lot about the drug business.
In this case, this isn't a question of they thought it was or wasn't. The officers all state, we know it's your bag. They believe it's his bag. And at this point, we're here today, he is stating, well, this is my bag, I'm challenging, I have this. But it's not an issue of notice to the officers. And we do not find that a person can just walk into a car dealership and say, these are my cars, and now all of a sudden have a right to anything there. Therefore, just on verbal denial alone, we shouldn't be able to abandon our property.
Can't you do that? Can't you go and say, I want to give this up to somebody who wants it, and say, I'm giving this up? Because it's already yours.
Is you're not giving it up until you physically handed it over.
Physically disabled, I can't move, but I can talk. I can never abandon anything.
Your Honor, circuit courts have found, and what we would say is, if a person was to continuously, repeatedly deny, and there are circuit courts that have found a denial once, twice, 3 times, 4 times, by that point, it's pretty obvious what they're doing. However, in this situation, we don't have but one firm denial, and then Mr. Porter turning around and answering questions about what might be in it and moving forward. We don't have a continuous denial that's repeated and to the point where it makes it obvious that he's trying to get rid of his property.
Kind of preliminary question before that. You said he had an expectation of privacy in the bag. Why do you say that? And here's the reason I ask. There's a statute that says when the police execute a search warrant on a house, that they are entitled to search all the containers in the house that could potentially conceal the items that are subject to the search warrant. It seems like that statute would define your expectation of privacy if you happen to find yourself in a situation where you're in a house where a warrant is being executed. So why isn't the existence of the statute enough to defeat his expectation of privacy and allow the search?
It is based out of the fact that the warrant in this case did not make mention of Mr. Porter, his property, or anything specifically about Mr. Porter. He is not in the warrant. He's not under the warrant.
Search property on the premises, which they're allowed to do pursuant to the warrant, and the warrant wasn't specific to the owner of the house. It was a probable cause warrant on premises, not on a person, which means anything in the premises automatically falls under the umbrella of probable cause.
Your Honor, a warrant has to specifically state what it is searching, and it would be searching relating to the things that were known to be there. In Mr. Porter's case, it is similar to State v. Brown, where they watched Mr. Porter walk into the house with that bag 30 minutes before they execute the warrant. They know that bag's not in there at the time it's signed.
I've read the warrant. The warrant doesn't say you can only search the things proven to exist at the time the judge issues the warrant. And the statute doesn't say that. It says at the time of the execution of the warrant, the officers can search anything on premises. So why isn't that sufficient to establish probable cause for the bag and to defeat his expectation of privacy?
Your Honor, I would go off of that, given that he enters with the bag beforehand, and we know that Mr. Porter has an expectation in his property that he has on him or that he would bring in there. A warrant cannot just catch all everything within there.
The record. So as I remember, Mr. Porter goes in with the bag while the cops are kind of surveilling, and they come in and execute the warrant, and then they bring Mr. Porter out to the van. When they bring him out to the van, where's the bag? Is the bag separate from him, or is it right next to him?
Once he's brought outside, the bag is actually in the corner of the room. It is where it's been the whole time. When the officers come in, they immediately detain Mr. Porter. It is sitting in a corner of a room away from him on the floor.
I mean, you know, I dissented in Brown, but that does the other Brown, that Brown case. But I think that that is a little different because, as I recall, Brown, the purse was right at her feet when the search was made. And here it's like, you know, if he has distanced himself from the object in some respect, why isn't it covered by the warrant at that point? You know, he's brought it into the premises and he's put it down there.
As the court in Brown noted, it is a matter of you won't hold on to all of your items at every second when you're inside someone else's house. You don't expect that another person can just start searching all of your things. You're not going to hang your coat on the coat rack and expect, I've now given up my interest in it. So the fact that he's not standing with it on him is different.
The defendant said when he was asked, is this your bag? What did the defendant say?
When he was first asked, that's at the point he says no. That is the one time he actually says, no, it's not my bag.
So how can you, and you also said that he has an expectation of privacy, but he says it's not his. How can you have an expectation of privacy on something that's not yours?
Your Honor, that is where we say that he didn't verbally deny it. So to finish my other point, it's because he has an expectation, they know it's his, it's found with his cell phone, his jacket, they know it's his property. Once he denies it, even if we're to find that verbal denial, just one verbal denial is enough, that this is not a voluntary verbal denial. This is not voluntary abandonment, because this is as a result of a coercive situation, or as we argued within the briefing, that it's as a result of a violation of his rights prior to that moment.
Violation of his rights. You're talking about his Miranda rights? And what was that exactly?
Mr. Porter is initially detained. They find he has a search warrant. They read him all Miranda. They bring him out to the van. When they're questioning him in the van, he states, I no longer want to speak about this. So they immediately cease questioning because he's now invoked his Miranda rights. They bring...
Invoked his rights to remain silent or his right to an attorney?
He invoked his right to remain silent. The district court's order references it's the right to an attorney. It's the right to remain silent. If you watch the video, that's what he did.
Guys, before he did that, I want to know factually, had he already denied the backpack? Was that inside?
He had,
Get rid of anything that he said afterwards, fruit of the poison tree. But he, at that point, had already denied ownership of that bag, right?
in the van, before he invokes his right to remain silent, they ask him, what about the blue bag he's brought in? And he just said, I don't know anything about that. This is not an equivocal, I'm giving up my interests, I know exactly what we're talking about, no, that's not mine. We do not allow a person to invoke their rights by saying, I don't know if I want to do this.
Observation problem with the Miranda issue here?
No, Your Honor. So we did not specifically raise that he had his Miranda rights violated. At the district court level, it was argued that it was a coercive situation, it was a coercive moment, and that he could not voluntarily give up his rights. We cited to State v. Grant, a Court of Appeals case in which they had done an illegal search. There was a violation of rights beforehand, and at that point, they found that it was so closely tied to the search that they couldn't find that it was voluntary. We argued it's such a coercive moment. In this case, the coerciveness can also be found from a violation of Miranda. It's
Point was his statement that I don't want to talk anymore, I'm worried about my dog, I need some air. Was that the kind of unequivocal invocation of his right to remain silent that we would find under our cases?
He said, I do not want to speak about this. And it's pretty clear that everyone knew he was invoking his rights because the officers ceased questioning and brought him inside to stop. They knew he invoked his rights at that point. And we didn't particularly bring this argument as a sub-argument. However, we brought the issue about a coercive situation and the fact that he was coerced into involuntarily giving up his right.
Whether or not someone's assertion of I don't want to talk anymore sufficiently unequivocal to be an invocation of Miranda, isn't that the kind of factual issue that you would need to have raised to the district court?
No, Your Honor, because our argument isn't that we're trying to suppress all of his statements. We're not saying none of his statements can come in, they violated Miranda, we're trying to eliminate these. We're not arguing that it's a matter of a factual if he invoked it or not. We're more so arguing that the coercive nature of a violation of rights is something that would lead a statement by Mr. Porter to not be voluntary.
At least the Court of Appeals there relied on it being an unconstitutional search. I think it wasn't, yeah, they had searched the pockets or whatever it was. So it was actually unconstitutional. So you're saying something less than a constitutional violation can still be coercive?
I'm out of time. May I finish with the question? Okay, so the issue is, in Grant, they're saying it's a constitutional violation. And in Summey, we know that, and we put in our briefing, that a person doesn't have to bring every single sub-argument to what we're doing. What I'm saying is that we're saying it is a violation because he says, I don't want to speak anymore. So we now have our constitutional violation, which is extremely closely tied to our now abandonment, or in our case, involuntary abandonment, because 2 minutes later, he's brought inside, questioned immediately. That's the violation of his rights when he's brought inside. We did not bring that particular argument stating to the court, find we have a constitutional violation. We brought, find that this situation is so coercive that this cannot be voluntary. In this case, we're now saying, hey, we can see that there is a actual violation of rights, which under Grant, we know would say this is an involuntary statement later. So it is just a matter of saying that it's a different way of arguing the same coercion that is the search warrant being done around him, the fact that he is in custody and being questioned, all of these factors that lead to coercion and that whole totality of the circumstance is what we raised before at the district court level, and we're asking now that it takes more than just one statement. We have to look at everything in the situation to determine that it was an involuntary statement of, no, I'm abandoning my property. Thank you.
Siefert or Siefert? Siefert. Okay, thank you.
50-50 people get it right. It's no worries. May it please the court, counsel. If you'll entertain me, I'd like to start with a quote from Bumpus 35 years ago, which I think really the natural extension of this should solve this case. It is clear that the defendant's intent was to rid himself of the evidence of the crime with which he was ultimately charged. In doing so, his abandonment of the property was voluntary, since his intent was to place the property outside the realm of his control. Since he no longer wished to be associated with the property, he could have no reasonable expectation of privacy in it. The only difference here are the circumstances that Mr. Porter faced versus Mr. Bumpus.
Back up to where he was just ending. Let's, for argument's sake, whenever the defendant said, I don't want to speak anymore, let's say from that point on, you can't use any evidence. Say that's going to be suppressed. What do you have before to support abandonment?
Two things before I directly answer. I will push back kind of with Justice Oxley's suggestion. I don't think it was unambiguous. I think it was equivocal. What he said was not, I don't want to talk anymore, I want an attorney. He said, basically, I want to be done, I'm not feeling well, and I want to see my dog. And so the officers said, you can be done. They took him inside. He's sitting next to his dog on a comfortable couch now. They're offering him water. And then the officer grabs the bag, a different officer, and says, whose is this? Is this yours? So I think there's an argument to be made that he did not actually invoke Miranda and that the officers properly understood what he wanted was to resituate and be comfortable and not worried about his dog before kind of the arguably problematic question happened. I would also say that if you look at
Miranda, what's the evidence that he abandoned?
For that, you had in the van the officer directly asking him, what about the blue backpack we saw you with? And he said, I don't know anything about that. I realize at that point, he didn't say, that is not my property, I disclaim it, but that's just not the way people talk.
Point, not take that bag with him out to the van.
He didn't. I don't want to strike out on softballs here, but I do think, he's handcuffed. I don't know that the officers were going to let the individuals walk around with items, but
Point. Thank you.
the initial entry under 8087, Justice McDonald, where under that statutory provision, the officers have handcuffed all three individuals for safety. Before they sit Mr. Porter in the video up on the couch, they both pat down and search the crevices of the couch and his pockets to make sure he's not holding contraband or weapons.
House to execute the warrant, was the backpack on his shoulder or was that away from him?
Here is we have three different kind of extended videos. I don't think any of the three show definitively. The earliest any of the videos show is kind of the one that shows the breach with the ram and then the officers come in. The first time you see Mr. Porter, I think he's standing kind of in the open doorway and then he's immediately placed and officers are yelling, get down. I believe at that point the backpack is over kind of in this area around where the love seat and the couch meet up. The first time you can visually see it, kind of by the white rectangular patch on the front of it, it's sitting over immediately adjacent to that kind of intersection area by the coffee table.
At least factually different from Brown where the purse was at her feet.
Actually different in that respect, yes. And I think,
She didn't deny that it was her purse, right?
and that's where I think Brown, and I appreciate the court's concern with analogizing Brown or distinguishing Brown. I also just think it's different than Brown, and that was the state's position in our brief. This isn't unclaimed property, and there's a question of what you knew. This is disclaimed property.
Still, it just bothers me to treat, I mean, your argument is a verbal denial of ownership should be the same as a physical act of, throwing property away or trying to get rid of it so it's not discovered. And I just have trouble with that. It seems to me that if we sustain your position here, the way the police are going to do, the way the police do the questioning usually is they say, can we search this bag? Can we search this car? Can we do that? Now what they'll do if what the state wants here becomes the law is the police will first say, do you own that bag? Do you own that car? Do you that? And then if the person says no, then they search it without asking anything further. And if the person says yes, then they'll say, can we search it? And it seems to me it tilts the balance in a way that's not contemplated by the law. I mean, you wouldn't be able to use a verbal denial of ownership as a conclusive basis to establish that somebody doesn't own property that, in the same way that you would if they had actually physically thrown it away, right?
I have a bunch of answers to different parts of that, and
Blair.
I guess my first answer to the very beginning premise would be I'm not as concerned about the equation of verbal and physical distancing. I think in both of the situations, and this is what I was getting to earlier, Mr. Porter and Mr. Bumpus, they did what they could. Mr. Bumpus had already been physically grabbed. An officer was in the process of arresting him. The best thing he can do, knowing that he has drugs in his pocket, is to just huck it as far as he can and try and hope that the officer can't find it. In Mr. Porter's situation, he's handcuffed. He really physically can't go toss the bag outside in a way that the officers wouldn't immediately pick it up. The only thing he really can do at that juncture is say, that's not mine. But he's trying, his intent is to accomplish the same task. He wants to hope the police can't actually connect him, which unfortunately for him they could because they watched him walk in with it.
This would be a rule of law that the verbal denial of ownership would apply only where the defendant is physically incapacitated? Is that what you're saying?
Saying in this circumstance, when you look at it, they're doing the best they could. I know in Mr. Porter's reply brief, he cites some cases from other states, one of them being, I think, the Evans case from Washington, which I cited in my own, as kind of this idea that verbal distancing enough is not sufficient. I want to push back a little bit. When I read those cases, my takeaway is that regardless of what the person says, you still have to look at all the circumstances. So
Case, it is even for abandonment, so this sort of property question, it is a totality of the circumstances question. Is that your view of it?
I think my answer is yes. I mean, I don't think you can.
And so if
actions and intent in abandoning it. If the question you're asking is totality of the circumstances, including information the officers arguably knew separate, I don't think that matters for the same reason that those federal cases allow two men who you see in front of you carrying briefcases, sit them down and deny ownership. The court shouldn't care about that.
some of the other issues that the defendant is raising here, those all sort of come in. We're not just looking at what he says. We're looking at all of the circumstances surrounding it.
And again, if I'm understanding your question, and really I'm looking at the language from Bumpus. So I forget what it is exactly. It's what you say, your actions, and other facts, some version of that. I think those are the circumstances you're looking at for voluntary abandonment. I think, sure.
Does your position depend on a finding of abandonment?
Doesn't. I think in the background, they also had other bases. In Brown, the holding of that said that this isn't foreclosing other avenues. We're simply saying you can't search visitors' belongings based on a warrant that doesn't list them.
Well, why do you need abandonment if they have a warrant to search the premises? Here's a bag that's not on a person unnamed in the warrant. He doesn't have the backpack over his shoulder. Isn't the backpack fair game for search simply under the warrant?
Dispute your take there. What I will say is, I guess the reason that I briefed it the way I did is, in my mind, it's an order of operations. And if you abandon it, you have no standing, you can't complain at all. We don't even reach any of the other issues because just as a matter of law, you can't make that claim.
And in Brown, where I said the burden, where there's a search warrant, the burden. Well,
the question is.
well, you're yeah, Mr. Newkirk can give a different answer, but if Brown, I pointed out, citing some authorities, that when there's a warrant to search the property, the burden is on the defendant to say this purse or this bag is outside the scope of the warrant. Whose burden is it?
So I think you were correct. I think the burden should be on the person disputing whether it's within the scope of the warrant to show that. And I also would mention, I think this case here in front of you now is kind of playing out some of the concerns that I quoted from your dissent in my brief, which is you don't know whose belongings are whose. You're trying to suss out this potentially active, dangerous situation. And this idea that you're potentially going to be relying on people telling you the truth to ascertain what you can do and what the boundaries are is just not a good decision. And if Mr. Porter is successful here, the lesson is going to be that we're incentivizing kind of game playing and lying and manipulating the situation because he can lie at the time to try and see if he can get away scot-free. And then when it doesn't work, he can still claim.
I'm trying to imagine what this would look like. Let's say that the defendant is successful in saying that bag was not abandoned, which means that it's not going to be included in the general warrant, okay, Brown. And you go get another warrant, and you say, we want to check this bag, where apparently it doesn't belong to the owner of the home. But your warrant application, I remember the days myself from approving warrants, your warrant application is going to say, and we don't know who owns it. Who's going to sign that warrant? We don't know who owns it, but we want that bag searched. We already had a warrant for the house. So I'm just concerned practically, what's this look like if he is successful in saying, I didn't abandon it? What can the state do?
Well, and that would be a problem. I suppose in this instance, I don't know if you can naturally assume that therefore belongs to the homeowner. The woman who was there, I think the evidence was that she stayed there but maybe didn't live there permanently. I think in this case, candidly, there probably would be probable cause. You have both gentlemen who were down in the room with the bag, kind of in the immediate constructive possession area of a bunch of other meth and drug paraphernalia that was in a separate baggie with the same kind of markers. There's a bunch more in the coffee table. So presumably, at least in this one instance, you would be able to construct a search warrant that would say, this is where it is. These are the two people that had constructive possession of it. I do take your point, though. I think there would be many other circumstances where maybe things weren't so clear. And once one person says it's not mine, I don't know what you do with that.
This constructive possession issue reminds me of the discussion in Brown, and to the extent that the holding there is clear, it seems like it's a constructive possession theory. As it gets near the end of the opinion, I think the rationale is something kind of like, well, the state likes charging people with constructive possession of drugs, therefore she had constructive possession of the bag, and therefore she had a right of privacy in the bag. So I think Brown poses a little bit more of a problem for the state here. if we were to follow its rationale, which is, I mean, he is being charged with possession of the contents in the bag. The marijuana charge and the meth charge, I think, relate in part, at least the meth charge is in part to the content of the bag. So help me through that, because I think a fair reading of Brown poses a pretty substantial problem, and I'm not sure the denial of ownership solves the constructive possession rationale of Brown.
I think I agree with your reading of Brown. I think what the court does is effectively kind of talks about those two older Iowa cases, then goes through the three suggested tests anyway and says the state would lose under any of these three. So I don't know that it actually chooses one, but certainly chief among the discussion points is this idea that when she was handcuffed, there's this, I think it was a photograph of her with the purse on the ground immediately adjacent to where she was being handcuffed. And that's where I think this case, I think it would be fair to say, was Brown if they hadn't asked him whose bag it was, because then the only...
That had his phone in it, and they picked it up and asked him if that was his phone?
I believe that is the facts. I will also say the officers had been picking up and moving items. I can't say based on the video or the testimony that that's how they encountered them. They were moving things around, trying to pull things out from behind the couches before they went through everything.
Of the constructive possession doctrine, in some sense, to impute possession to a person, even though they're not explicitly claiming an ownership and interest in it, and frequently denying it. I mean, so in a typical drug case where somebody's charged with constructive possession, 4 people in a vehicle, everybody says, no, that's not mine. They deny ownership, and you say they have possession. I'm not saying that Brown was right or that reasoning was right, but a fair reading of it is that constructive possession theory of Brown seems to answer this argument that the defendant's making.
And so I think what I would say to that, if your honors will entertain me going, since you're asking questions still, I think the difference here is a little bit, again, in pieces. I think I will push back, as I did in the brief a little bit. I don't think the officers can fairly be said to know the bag was his. They knew he possessed it, certainly, earlier. But again, that could have been just someone bringing in a bag full of drugs to then deliver to the person who owned the bag, who lived there. I think...
I want you to finish the answer, but, I mean, think about what you're saying. I mean, he's being charged with possession of the drugs in the bag.
Just as...
This is kind of the theory of Brown, is if it's good enough for the state to charge the person with constructive possession of the drugs, then that's sufficient to satisfy the standing requirement under Article 1, Section 8 for the search and seizure issue.
I still think it's the same as Bumpus and those federal cases. It doesn't matter that we saw you with the thing. In Bumpus, we know he had the drugs in his pocket, and then he threw them, and now it's a different situation. It may be that we knew he constructively possessed it, and we obviously still charged him, but kind of the fact is that when you, under these cases, affirmatively, voluntarily disclaim your ownership and association with it for the purpose of creating this space to see if you can, maybe they couldn't prove constructive possession, maybe they hadn't been watching. When you do that, you now lose any reasonable expectation of privacy and you lose your standing.
Not asked us to overrule Brown, right?
I haven't, again, because I don't think you need to. I think this is a separate question because it was disclaimed rather than unclaimed, but the state will not push back on that suggestion. Thank you.
You.
May it please the court? I would actually dispute on the facts that I believe the officer testified at suppression hearing that there was a jacket and a phone. And if you watch, prior to the search of this bag, The officer picks up the jacket, is going through the jacket, is going through, has the phone. It's known to be his. This isn't a situation kind of like what was raised in Brown in the dissent. This isn't something where it's like, well, it's near them, but we don't know. This is something where officers keep telling him multiple times, this is your bag. They know it's his. This isn't a question they have to figure out. There's no issue there. They're on notice. And it's not a situation where it's just left away from everything else. It is left with his other property. Leaving the things together indicates he expected to have his privacy within that house and that he expected his things to be safe there together. He wasn't getting rid of it.
So if I were a district court judge and an officer came to me and said, we're executing a search warrant at this house. We found a bag on the ground. No one's asserted an ownership interest. I would like to get a search warrant to search the bag. I would say, I already issued you a search warrant that allowed you to search all the containers in the house. Go search the bag. I mean, isn't that how this would play out in the real world?
This really, because under this assumption, we're assuming that they don't know whose bag it is. This is different than that situation, just in the fact that they know it's his bag. They know it's Mr. Porter's bag, and when they ask him questions about it, they know it's his. However, in that case, it would be pretty obvious that, hey, we found a bag, it's within there. In that situation, when we don't,
And they went back to the judge would say, Code Section 8087 says, search all the containers on the premises at the time of execution. If they can contain the contraband, my warrant already says that you can do that. Go execute the warrant.
I believe some of the issue comes from, first in Brown, part of the issue is warrants are supposed to be particular to what we're searching. We're searching this house, and we don't find that a person just loses all expectation of privacy. They don't lose their rights because they go to someone else's house. And Mr. Porter went there knowing he had privacy in that. That warrant should not cover it because by the time it was issued and any probable cause, anything known to that warrant does not relate to Mr. Porter. In your situations, what we're looking at is if they don't know whose it is, it falls under the warrant. In that situation, we don't need to get another one if they don't know. They know it's Mr. Porter's bag. At that point, they need to establish a different level of probable cause to Mr. Porter and his items and what he had to be able to then search those items. It goes to the knowledge.
Your argument is this, is you can have probable cause to search persons, things, places, and here the warrant is to search a place and all the things contained in the place without distinction to ownership. And so, and this to me is also the kind of the analytical problem in Brown where it discusses warrants as if they have to be particularized to a person and they don't. This one is particularized to a place and the things in the place. So I'm not sure why we would have to suppress evidence that was collected pursuant to a valid search warrant and pursuant to the code.
Under the fact that Mr. Porter, his property, which is not in there at the time this warrant's contemplated, we're getting probable cause to search what's in that house based on what has been happening up to that point. That's what we know a warrant to be. We're establishing through the affidavits all these things that are in there we expect to be in there because of this.
Moving target.
Suppose, I mean, yeah, here's the problem I have with this, Mr. Newkirk. So suppose the bag had a big label on it, you know, like I put on my luggage, just said, you know, Mr. Porter's bag, and it was sitting there right there, but it wasn't brought, and he's there, he walks in, but he didn't bring the bag in. You're saying in that circumstance, it would be covered by the warrant and it could be searched.
At that point, if they'd seen him walk in and that property is in there, it has to do with the fact that we need to be able to establish to him and his individual property. I believe there's Supreme Court cases that have noted that we search your house, we have a warrant for house, we have this particular evidence to this person, that person's belongings, these things.
It's you know, there's a tip that there's a terrorist cell that's meeting at a house, and they see 10 people walk in there, and they're all carrying a bunch of bags, presumably have, you know, semi-automatic weapons and bombs and things like that. And they all put those bags in there into the house when they're meeting. And the police can't search any of that because it's all property that these individuals brought into the house. That seems, I mean, it does seem like there's maybe an analytical problem with Brown. And I think I did join that dissent, now that I think about it.
Your Honors, if I may continue, okay. Within the issue there is, we don't allow a general catch-all warrant. That is just not, the case law is clear. We don't allow catch-all. We have to have some level of specificity of what we're looking to do. And in these particular cases, that situation, if you see them walk in and you see this property, it goes to part of what was the reasoning in Brown. It's that they have noticed that this property is not included in what's within it. We have a person that's completely unrelated to any activity, any of the drug dealings, anything else. They're just merely there.
Moving target, that seems really silly to me. When I sign a search warrant, let's say we think there's some drug activity going on there. We think it's meth. We think it's all kinds of drugs. They've got all the paraphernalia, and they nail everything. And you get in there, and since the drug business has initiated, they've also decided to start doing child porn, and they find some child porn stuff in there. Are you telling me that's off limits from anything as far as if they find anything that has to do with another crime? Are you saying stop right there?
That once they get in there, case law is established. Once you're in there, you have a reasonable basis to be there. You have justification to searching what you're searching. Once you find it, you can have an independent probable cause to have searched anything else. If the state would have come here and said, we have an individual probable cause now to search Mr. Porter, then we have a different discussion. But the issue is that warrant was not encompassing property that they actively watched him bring in. It wasn't in there. This person has no association with anything else. And we've established that
But that's just factually not correct. I mean, I've read the warrant. It specifically says that they can search containers in the house. This was a container in the house. So it is within the scope of the warrant.
basis that that warrant written to someone else's house, someone else's property, shouldn't now encompass a person that wasn't even thought of when they wrote it. Or a person's.
Written, and we think of it when it's approved. Drug dealing involves giving and taking and lots of customers. How can you say that's not anticipated?
Point, we're assuming that just because someone has gone to a place where illegal activity could be done, we're now assuming they're involved in this probable cause to search all their items. But we have found that we don't make that assumption. We don't assume that you're necessarily doing something illegal or have illegal things just because of where you're at. We require some sort of actual reasoning to establish to that individual person or those individual things. And this is just a different situation. And it's different than in Brown even because they know. They're on notice. They specifically know the property.
To Justice Mansfield's question, I think you're putting value on the officers seeing Mr. Porter walk into the residence with the backpack and that they have some sort of notice that at one time he was in possession of it. Is that correct?
I am putting a lot of value on that.
Why is their knowledge relevant to his interest in the bag? If your claim is he inherently has some sort of interest in the bag because it's his, why does it matter that they saw him with it at some point in time?
Part of the issues that were laid out in State v. Brown, it's the fact that we know that officers can't be expected to go and search. We're not asking that every single thing they have to verify individually per person who owns what. And in State v. Brown, the ruling was based off of they had notice. Like they established at the end of that case, like they were on some level of notice. In our case, Mr. Porter, this is different. They are very aware of what is his property. They watched him. They can see it all stacked together. They're aware of his separate and individual privacy interests in that bag because they've seen it. They're on the notice that was laid out in State v. Brown of that third party. A person does not necessarily lose all of their privacy interests just because they enter a home where a warrant is being conducted. It is the absolute complete reason why he still has his privacy interests in there. That warrant doesn't actually attach to his property. It's because they're aware when they're executing it, it is not something that was part of that warrant specific to that house. It is part of Mr. Porter and his property and his privacy interests, which is not contemplated. I say not contemplated as in not specifically listed.
You and I talked earlier about sort of what it would take for him to have abandoned, and you're suggesting it'd have to be some sort of physical act, but he's handcuffed here, right, at this point?
Goes back to not just the physical act, but how some of the circuit cases have found repeated denial. If he had consistently said, no, it's not mine in the van, if he firmly said it's not mine, then goes outside, says, no, it's not mine, and as they start asking, hey, what is in it? And he goes, no, it's not mine, no, it's not mine, we have a different situation because he'd be repeatedly denying ownership. This case, we have one denial, and what we're saying is one denial, when you look at all of the totality, which is they watch him walk in with it, they see it sitting at his feet.
That's our call on de novo review, ultimately. Enough, fair?
It is your discretion to determine what you find to be sufficient.
Or one time, he said no.
Yes.
He said, it's mine, that's mine. Hey, 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 that's mine.
Affirmative action of saying, yes, it's mine. But the closest we get to is, like I said, once they start asking what's in it, he's answering, no, that's not. They say, is your inhaler in it? No. Is there drugs in it? No, nothing like that. He isn't denying anymore. He's answering questions about the bag. But there is only one firm denial. But as noted in, I believe, the U.S. v. Hawkins case I referenced, we don't find that a person can just automatically claim ownership by one statement, and we shouldn't find that he can just give up all interest based on just one statement saying no.
Burden to prove that that bag was outside the scope of the warrant. How does he meet that burden by denying it's his?
Your Honor, it is his burden to find that it's outside the scope of the warrant, but the warrant did not list him. It didn't list his property, and the officers testified they knew they walked in. So at the point they're aware it's his, he has a privacy interest in his property, and he doesn't lose it once he's inside, it's outside the scope of the warrant because it's not written there, and they know it. At that point, it is on the state, it's their burden to prove, now that he is standing, because there's no warrant, it's not attached, it's not part of it, the state must prove that he voluntarily abandoned that property, because once he's not part of the warrant, he has standing. And his burden is just to show there's a warrant, it's not encompassing him or his property, and that theory is under the state v. Brown, the third party still has it, and it becomes the state's burden to prove that he voluntarily abandoned it. Thank you.
The case of State versus Porter is hereby submitted, and court is adjourned for the afternoon.